Most people think of a DUI record as one thing. It is actually three separate records, and they work very differently. You have your criminal court record, your public DMV driving record that employers and insurance companies can see, and the DMV's internal record. Each one has its own rules for how long it lasts and whether it can be cleared. The criminal record is what courts and background check services report. A California DUI conviction stays on your criminal record permanently unless you take action. However, California Penal Code 1203.4 allows you to petition the court for a dismissal, sometimes called an expungement, once you have completed probation. This does not erase the conviction completely, but it changes the record to show a dismissed case, which can help with many job applications. It does not clear the record for state licensing boards or certain government jobs, so it is not a total clean slate. The public DMV driving record is what insurance companies and employers typically pull when they run a motor vehicle report. A DUI conviction appears on this public record for 10 years from the date of the offense. After that 10-year mark, it is no longer visible on the standard report insurers and employers receive. That is why your insurance rates often stay elevated for roughly that same period. Here is the part most people do not hear about. The DMV keeps a separate internal record, sometimes called a transcript, that is permanent. When the 10-year mark passes and the DUI drops off your public driving record, it does not disappear from the DMV's internal files. If you are arrested for a DUI in the future, that prior conviction can still be counted, because law enforcement and the DMV can access the internal record. There is no procedure to remove a DUI from the internal DMV record. California Vehicle Code 23152 is the main DUI statute, and when prosecutors charge a repeat offense, they look back 10 years from arrest date to arrest date. A second DUI within that 10-year window means mandatory minimum jail time, a longer license suspension, and a required 18-month DUI program instead of the standard 3-month one. The 10-year lookback is tied to the arrest dates, not to what shows on your public driving report, so even if something is fading from public view, it can still count as a prior. The most practical step available to most people is the Penal Code 1203.4 petition for dismissal on the criminal side. Beyond that, completing the DUI program, keeping your record clean, and waiting out the 10-year public DMV window are the main paths forward. Results vary case to case, and the facts of your situation determine what options apply to you. Understanding which record you are dealing with is the first step to knowing what your real options are. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.